Good afternoon, everybody, and welcome to our session, Let's Talk Patents. I'm delighted to see you all here, even if virtually, and talk to you about our interest in patents and IPR more generally. I'm a strong believer in patents and other IPR measures because I think they are key in the deep tech research and deep tech innovation in general. The early detection and protection of our research and innovation not only can facilitate the future exploitation of scientific results, but support licensing and of course give value to any resulting companies. I mean here, first to secure the access to finance of this company with investor or banks, because clearly they will, one of the first things they will ask you will be about IPR, but also with customer. I mean, I've seen many times when we are organizing this procurement, these corporate days or innovation procurement days, they ask and the companies present what's their IPR that is protecting their products. So without further ado, I'm delighted now to welcome our esteemed speakers today, Mr. Frédéric Marteau, manager and at the EPO in charge of technology transfer and dissemination, Mr. Luís Alves, full professor in the Department of Physics of Instituto Superior Técnico, Mr. Bruno Soares, president of the Instituto del Plasma e Fusão Nuclear Instituto Superior Técnico, and Mrs. Elena Stefanova, head coordinator of Pegasus project and leading researcher of plasma engineering at the same institute. You understood we have really excellent speakers today to introduce you these topics. Without further ado, Frédéric, the floor is yours for a maximum of 25 minutes. Thank you.
Thank you, Mr. Pekka. Good afternoon to everybody. I'm really delighted to be able to present on behalf of the European Patent Office and the European Patent Academy this talk about patenting and invention at the EPO in a nutshell. I will first start by introducing the European Patent Office and then dive into the core of this presentation about the what and the how patenting. I will close by giving you training resources as well as the important take-home messages. The mission of the EPO is to provide protection for invention with patent in up to 40 European countries. The EPO is the second largest intergovernmental institution in Europe after the EU. So the EPO is not part of the EU, it's an internal organization, was basically instituted by treaty in 1973. We are self-financing, we have a budget of about 2.4 billion euro, and we are about 6,400 employees, with about more than 60% are highly qualified patent examiner, engineer, scientists, PhDs. And we are located in Munich, The Hague, Berlin, Vienna, and Brussels. The EPO is covering 700 million inhabitants. There are 38 member states, which is Europe in a broad sense. For example, Iceland is also part of the European Patent Office. And we have also extension state and validation state, which are 6 countries where we have agreement in order to allow to use our result of the European Patent Office work. Now, the core of the presentation. What is a patent? A patent actually is a social contract between the inventors and the public. Basically, by the inventor revealed to the public their technology, which would help to further improve this technology. And for revealing this technology, they will basically get exclusivity. They will get a right to forbid people from exploiting their invention. So the benefit to the public is that the society get a detailed description of the invention so that anyone can understand it and improve it. And it's published after 18 months after the filing of the patent. And the benefit for the owner is basically get the right to stop anybody from exploiting the invention from a commercial purpose without his authorization. And this right is valid up to 20 years. Should keep in mind that patents only protect technical inventions. There are other IP rights, such as the author rights, the trademark, the design, the drawings. But patents are for technical invention. How does the patent look like? The main important part of the patent are the description and the claim, as well as the drawing. The description and the claims are mandatory. And most of the time you have as well drawing to support the description and the claim. So you have also the inventor, the applicant. You have a date of filing, which is, you will see later in the presentation, really important. The date of the publication. That's the component of, as you can see, a patent application, a published patent application. Now I will explain to you the general structure of the description. And for this purpose, and along this presentation, I will take the example of a simple invention, a teapot with 2 spouts. You start usually the description by explaining what exists, what is called the prior art. So it's basically a teapot with 1 spout. Then you also explain the problems, the drawback with this prior art. It's time consuming if you want to pour tea in several cups. Then you go to explain the problem that your invention wants to solve by reducing the filling time, the solution, in this case, you provide a 2nd spout, and then the advantage. This is what the description should contain. Then you have the claim. The claims are important because they define the scope of protection. They really define from a legal point of view what will be protected. And it reads like that for this example. A pouring vessel comprising a compartment for liquids is the number 1, a handle, number 2, a lid, 2 spouts with number 5, extending from this compartment, and the 2 top of the spouts are arranged at the same height. It's really important. All these technical details define the invention and the protection that is searched. Now that we've seen what is a patent, what can and cannot be patented. Not everything can, in the field of technology, can be patented. First of all, the European Patent Office, under the EPC, the European Patent Convention, it gives patent for 2 types of invention. The physical entity, which can be a product of an apparatus. For example, you see you have a list of a few, a chemical compound, a washing machine, in this case, a plasma machine, a vaccine, or also methods, processes of use, manufacturing plastic films, removing artifacts for MRI imaging, using substance as an insecticide, or for example, as a medicament. These are the 2 types of invention that are allowed. However, there are inventions that are excluded. We have a long list here of everything which is excluded. For example, discoveries in scientific theories cannot be patented. And it's important that all these lists is when it's claimed as such. I will explain why you cannot, for example, patent a scientific theory as such. Take an example. You discover a new phenomenon. For example, in physics, supraconductivity. It's a discovery. You build a theory explaining how does it work. But you cannot get a patent for the discovery in the scientific theory. However, you can get a patent, for example, for an apparatus that uses this effect to solve a problem. For this apparatus, you will get a patent, not for the discovery. It's the same with computer program. You cannot claim a computer program as such. But if you have a computer program that runs on a robot that helps the robot to calculate and to guide the arm of the robot, it's also patentable. Now we go to the 2 exceptions, not more exclusion. There are several things that are not acceptable in some fields. For example, in biotech, you can get a patent for biotech invention, but not for some exception. For example, plant and animal varieties and process for production of plant or animal, essentially biological product, cannot be patented. Also, in any field of technology, when the invention goes against the ordre public and the morality, you cannot get a patent. It's basically the cloning of human beings or a method of torturing people. It's not allowed. And in the medical field, the method for the treatment by surgery of therapy or the diagnostic method on the human or animal body are actually not patentable. It's to keep the doctor the freedom to choose the best method for curing or diagnosing. Now, what are the criteria? There are actually three main criteria, which are that the invention must be new, inventive, and industrially applicable. We will now go into what actually does mean new and inventive, which is really the core of patentability. An invention is new when it's not part of the state of the art. You would ask, what is the state of the art? It's basically everything that was made available to the public before the date of filing. For example, I file today this patent for this teapot. State of the art will be everything that was made available to the public until yesterday midnight. Which means that it's really important to keep your invention confidential until you file your application, and that the EPO give you a date of filing. That you filed, this is the date of filing. It's really important. So basically what you shouldn't do is publish in any way a press release, article, conference, a book, in an interview in a newspaper. Also, all the oral disclosure, if you give a lecture, if you present to the public your invention. Also, if you sell a device or product with the invention incorporated in that, it's called prior use. You will be in trouble with your filing date because it will be considered as your own, as prior art, your own publication. So the best is, for example, if you discuss with investor and you not filed the patent yet, sign non-disclosure agreement. It's also recommended to search professional advice to avoid to make such mistake. And the best advice is just file as soon as possible. So be the first to file. Now, I will try to explain clearly, simply, how the EPO is assessing novelty. So now the examiner has this patent application with this claim about this teapot, and he will search in the big database that the EPO has with hundreds of millions of documents, patent document as well, and scientific article, a lot of database, whatever it exists, or what is the closest to this invention. So we basically take these, the claim with all the characteristics, and he will search in it. He will search the prior art. So let's say that he found document D1. It's the classical teapot with a lid, handle, reservoir, and one spout. Then you also come across a document, which is for spraying fertilizer on the field. It has also two spouts, two rods with nozzle to spray. It has a reservoir, but it doesn't really have a handle or a lid. Then you also select document D3, which is a filter handle for using an espresso machine. You also have a compartment for the liquid, you have a handle, you have no lid, you have one spout splitting in two, and the two spouts are arranged at the same age. So you're also close to it. You don't have everything, but you're close to it. And then he found this nice, fancy bottle for vinegar and oil, where you have this reservoir. You have also two spouts. You have also no handle. You have lid, this cork thing. But the two spouts are not arranged at the same age. So you're also close, but you don't have all the feature. It's for the examiner, let's say it's the best 4 document he found. Now, he compares, and you can see that the invention, the claim, none of these documents have all the feature of it. So we will basically then conclude this invention is new. But now we will assess inventive step. So at the EPO, we use a structure method called the problem solution approach to assess it. And we make use of a legal fiction, which is called the person skill in the art. So basically, the person skill in the art is a skilled practitioner, somebody who can practice in a specific technical field. He knows he has access to all the knowledge, and he has himself a general technical knowledge, and he's capable of routine work. He can put things into place, work, but he's not an inventor, definitely not. He cannot invent or see beyond his daily work. So now the examiner, which is in charge, will go through three steps. First steps, he will define what is the closest priority. If it's new, you should find something that is the closest. He counts it's the classical teapot. Then the stage 2, he will fix this problem. You remember I say we use the problem solution approach. Now, first he has to identify the problem. He will basically look at the difference over D1. So the thing is that the two spouts, there are two spouts in play instead of one, and the particular arrangement, they are coming out of the reservoir and they have the top at the same level. Then you will define the technical effect of the difference. Basically, the time needed to fill multiple cups is reduced. It's faster to fill it. And then deduce the problem. The problem is how to modify the teapot of D1, this classical one, in order to reduce the time needed to fill the multiple cups. Then you go to the stage 3, where our legal fiction, the skilled person, is coming into play. The skilled person will just try to find how I can modify the D1, the classical teapot, in order with what the other document to solve this problem and arrive to the invention to these two spots. Is it possible to combine? That is an obvious combination in order to solve this problem. You should remember that the skilled person belongs to the technical field of the invention, which means that this person is the skilled person for the kitchenware. For sure, we will then not look at D2 because D2 is in a remote field, it's agriculture. So we'll not look at it. At D4, does D4 solve the problem? The two spots are at two different levels and you cannot pour oil and vinegar at the same time. So you cannot reduce the time filling. Then you will go to D3. In D3, it's promising. However, from the reservoir, there is only one spot that comes out and then split into two, which means that although you have two spots, the flow is divided by 2, and therefore you're not reducing the time to fill multiple cups. Therefore, the examiner will conclude that the skilled person could not combine D1 with one of these documents in order to arrive to the solution and solve the problem. And the examiner comes to the conclusion that this invention is inventive. So now we go to the procedural aspects. How do you get a patent in the EPO? You have basically 3 possible routes. The national one, you go to national offices. It's valid in one country when you get the patent. You go to the European, when you find a single application in English, French, and German, because these are the 3 official languages of the EPO. And then you have one procedure with the same effect in all these countries, the 38 countries plus the other 6 states. And then you get a patent that would be valid for all these states. There is also the international procedure, which is not a procedure leading to a patent, but a procedure for filing that gives you afterwards more choice, but I will not go into detail. The basic step in the European grant procedure are there. First of all, you file. You have to file the patent with the description, the claims, even drawings at the EPO. It's important to know that anybody can file a patent, whatever your natural legal person, irrespective of where you live, your nationality, your place of business. Everybody can do that. For the proceedings in front of the EPO, for proceedings in front after the filing, you can do it on your behalf still if your residence or principal place of business is in one of the contracting states. If not, for example, you're in the US, then you have to appoint a representative. And the EPO provides a list of official representatives. Then you go back. After filing, you got a filing date from the office, then it's the search report. An examiner is in charge. He will basically search in the database, try to find, as we discussed, the document clauses, and then he will draw an opinion, give you the document, and basically give his opinion with regard to the legal, obligation, specifically about the novelty and the inventiveness. He will do that before publication, because after 18 months, the patent is published. It's important because it becomes visible to the public. So we are now giving the public the possibility to see. It also gives rise to provisional rights. You can use this publication to go to court to try to stop people. It's provisional, but still you have some rights that are here. And also it's public. So it means that maybe your competitor knows about it now. So if you decide that you're not sure that you will continue in this business, you don't want the competitor to know, so you can withdraw the application. If you withdraw before publication, nobody would ever know that you did file this patent. Then you ask to the EPO, I want to proceed to examination. You pay a fee and the examination starts. Now the file is with 3 examiners, a panel of 3, 1 in charge. It's usually the one who did the search report before. And he will basically see if these claims are in line with the European Patent Convention. You might exchange with the division and the applicant, and then try to change the claims in order that it's define an invention that is new and inventive. Should be really take care that you cannot change the patent application. What you have filed in the beginning, the contents stay the same. The claims might be adapted, but only in the framework of what was in the application as filed. You cannot add content, a new part of invention. And after 3 to 5 years, if everything goes well, you get a grant. So you get a patent, which is not enforceable directly. You should go to all the national offices if you want. You pay a fee. Eventually, then you have to file translation. And then you get a national patent that you can use. It's not completely over with the office, the EPO, because you have still, from the day of granting, a 9-month period where anybody can file an opposition against your patent. For example, it can be your competitor because they consider that it's not new, because they know another document that was not found or cited by the EPO, or for several reasons, it can try to invalidate your patent in front of the EPO. There is also the case where after all this, there is no agreement and the office does not agree with the claim that you wanted to have protection. Then the office will basically issue a refusal. And as in any legal system, you have a second instance. There is a board of appeal of the EPO, which is an independent body, when you can basically file an appeal and ask them to review the decision of the first instance. You have 2 months after the refusal is issued to file an appeal, and 4 months to give all your reasoning, all the reasons why you think this decision was not correct. Now, I will give you training resources provided by the European Patent Academy. So the European Patent Academy, where I'm representing, is providing a lot to the different audience. So the applicant, the judge, the national patent offices, universities, research centers, SMEs. And you can find all these resources at epo.org/learning. I will show on this slide, for example, what you can find. You have applying for a patent, and you have, for example, all the upcoming training and courses event. For example, there is examination matter in December, 4 days when they explain to you all these examination process. It's online. Usually it's in person, but due to the corona, it's online. But then you have the material, plenty of material. For example, the inventor handbook, with everything you should know before filing a patent. You have also conference report, for example, about blockchain or specific technologies. And also really important e-learning resources, a lot of e-learning resources, a lot, and coming more in different formats for free that you can basically learn, for example, how to apply for a patent. A general one is today, or a more specific one, patentability in healthcare, biotech, or with ICT. There is a lot of resources there. I invited you to go there to see. And now the take-home messages. If you have to remember only a few things, these things. When you file your patent, you should disclose the invention so that it's clear and complete, so that anyone can carry out your invention. The filing date is really important, because if you disclose your invention before, you have the risk for invalidating your patent application. Third point, from the beginning, you should put everything in the patent when you file, everything that you can, because you cannot amend afterwards. The content stay the same. It's always advised, as a fourth point, to ask a representative, an official one on the list of the EPO to help you with that, because it can be a lot of flavors to that. And then last one, the European Patent Academy provide a wide range of training services online to help the applicant. So go and search for help here. So thank you for your attention, and you can reach us on the social media. Thank you for your attention.
Hello, everyone. Thank you very much, Frédéric. It seems that we have a problem with our colleague Viorel joining, but thank you very much for this interesting presentation and the explanation about the patents. I think it has been quite clear. I see some questions in the chat, but I will let them for later. I will like now to give the floor directly to our colleagues, Bruno, Miguel, Soares, and Elena, Stefanova, Tatarova, that they're gonna talk about the project Pegasus from the Instituto de Plasma y Fusão Nuclear. Please, the floor is yours. Luís, I think you are muted. Yep.
No, it's Elena that should unmute.
Elena, please go ahead. Sure.
I'm sorry. Good afternoon to everybody. Thank you for the invitation for this meeting. Today, with my colleagues, are going to share our experience regarding the development of a patent portfolio of versatile plasma-based machine for a large-scale production of graphene and derivatives. The machine is being built in the framework of Open Pegasus project. What is so appealing about graphene? Recently, graphene hit headlines as a new cutting-edge material. This one-atom thick crystal of carbon gathers a set of unique physical-chemical properties ranging from its extreme mechanical behavior to its exceptional electrical and thermal conductivities, and appears as a serious alternative to replace many conventional materials such as graphite, silicon, silver, copper, or steel. However, in spite of the initial enthusiasm, large-scale application of graphene have not experienced take-off yet. The reason is very low quality of commercially available graphene and derivatives. Recent study has found that the majority of companies are selling a product containing less than 10% graphene. In the framework of Pegasus project, we created disruptive plasma technology and corresponding laboratory prototype for a large-scale fabrication of high-quality graphene and derivatives. Why plasma? Plasmas are medium with highest energy density. Plasmas have unique ability to control the energy and matter fluxes at atomic scale level. Therefore, full control on the synthesis process at nanoscale was achieved. This is the main advantage of the method when compared with conventional ones. The plasma method employed is environmentally friendly, with no use of harsh chemistry, cost-effective, continuous fabrication at a single step at atmospheric pressure condition. The method is green, contributing to circular economy by using cheap renewable materials, starting materials. Pegasus is simple to use, versatile, and scalable technology. Using the same machine, applying special protocols, different nanostructure can be fabricated, such as pure graphene sheets, nitrogen dot graphene called N-graphene, graphene quantum dots, composite materials by using graphene as a highly conductive matrix to incorporate metal oxide sulfides nanoparticles. Potential applications are numerous, ranging from energy storage and conversion devices to jet inks. Pegasus machine provides higher quality graphene derivatives than existed on the marketplace, as evidenced by comparison with the quality of M graphene provided by reference supplier. As seen, the fingerprint of graphene in Raman spectra is missing in reference supplier graphene. Now I'm giving the floor to Bruno.
So the advantage of our production method that we were able to scale up to a industrial level prototype is that we are able to produce these graphene derivatives at a very low cost, at around 70 euros per gram, which is 15 times lower than the graphene existing on the marketplace at the moment. Furthermore, we are able to produce graphene flakes and N-graphene, as the example that you have there on the table, with very high quality and very low oxygen content. So this is very competitive, and it's much better or much higher quality than what we have on the market. So as you can see on this next slide, our technology is much better than competing technologies. Elena, could you please change? Than existing technologies, where in several different relevant criteria. We don't use any catalysts, we don't use any chemicals. We are able to produce these graphene and graphene derivatives at room temperature. Very high purity and high quality material is also produced. It is a single step method. We have in situ doping. We make it at atmospheric pressure, therefore no vacuum systems are required. And the availability of raw material is very large, as we can use alcohols, oils, biomass, and argon. So this is very unlikely the other methods of producing graphene that you can find on the market. So we tick all the relevant criteria with our device. So basically, next slide, please, Elena. We have a disruptive plasma machine that enables access to high quality graphene derivatives. This is unlike the low quality graphene derivative products existing on the market. These devices ensures continuous production of consistent batches of graphene derivatives. And what we are doing is a device that can be used by graphene users or consumers to develop new products and new devices. What we are doing now, and that was included in the project, if you can go to the next slide, Elena, please, was to build this need to go to the market into our project. And we have a team that comprises the engineers and the researchers that have been working on the device, but also we have been dealing from the start with intellectual property and the business models and commercialization in our project. So what we have achieved since 2016 is a very steady progress towards industrialization. We have now today immediate capacity of productions and sales, and you can see that we range from a proof of concept where we were producing 0.01 milligrams per minute to a production scale of 50 milligrams per minute today. So at the moment with these industrial prototypes, we are ready to supply the market with versatile plasma machine for producing high quality derivatives. And part of this aspect and part of the aspects that are important is the intellectual property and all the patent process and the patent portfolio that was generated by the project that my colleague Luís Alves is going to explain now. Thank you.
Thank you very much, and good afternoon, everyone. So now for the second part of this talk, I'm going to focus on what and how to patent, and basically I'm going to leverage on our own experience as an example, highlighting some of the aspects that Frédéric already mentioned in this previous talk. So the first important message here is that you cannot simply patent an idea. You need to make the idea a reality to be patentable. You need to make sure that your invention is new and unique and not just a variant of another known invention. And so you must start by doing a preliminary search in papers and patents to check if the invention already exists, and to define what we can call the state of the art, so the so-called prior art in intellectual property language, relative to your invention. This can save you a lot of time and money, especially if you find that your invention isn't original after all, contrary to what you thought in the first place. And sometimes the results of this search can turn against you. If you have published some results beforehand, if you told your idea to someone before, things that you should not do. And actually this happened to us. So in this search results, there's a couple of documents that actually were previous publications from the group, and that at the end of the day defined the prior art of our invention. So we had to struggle against ourselves during the patenting process. The second important message is that you should categorize your invention. So basically trying to answer the question, what is my invention? Is this a new product? Is this a new process for manufacturing a product? Is this a new apparatus or some means to manufacture the product? Or is this a new use or a design application for a product? Or is this some combination of the topics above? In which case you should have some interlinking between the previous topics in order to ensure the so-called unity of the invention. In our case, we had too many inventions to handle within the same patent. So we had a process, a system, and a reactor. Indeed, we had some problems demonstrating the unity of the invention. So a good advice maybe for you to handle this problem is to maintain meticulous records of your invention. This will help you to define the invention. So by meticulous records, I mean, for example, diagrams and supporting documentation that explains how the invention works. Also documentation explaining even your inspiration during the inventive process. If possible, if you have schemes, photographs of models and prototypes, this is not mandatory, but it is great if you have that. And if you have a working prototype of the invention, again, not mandatory, but it's even better if you have them. And we were fortunate enough to have them both in our particular case. Now, as part of your plan ahead strategy, you should decide why to patent. Do you want to patent because you want to protect your invention? Or maybe you have some specific goals, or maybe you are already starting to plan future businesses decisions. About protection, that's an important point that Frédéric already highlighted. Notice that patenting is not a way to keep your invention a secret, because the patent will be eventually published in public sites like the European Patent Office. But the invention will be protected after a certain date, the so-called priority date. This is usually the earliest filing date of the patent. So even you can publish your invention, but only after the priority date when the invention is patent protected. Finally, you should also think about where to patent. You need to identify the countries where your major competitors are. And you need to make sure that you have secured enough funding to file applications in all these countries. Indeed, patenting an invention can be quite expensive. So maybe you need thousands of euros to prepare the patent, and this includes hiring a patent lawyer, and then to pay the submission and maintenance fees. Of course, you can always look at this patent process as a sort of an investment. So you spend money first to retrieve it later on. Hence the interest of making business decisions as soon as possible, as mentioned before. Now that you have decided to patent, you should then learn the language. Patent language is quite different from scientific paper language. And maybe you want to read other patents when you start to understand this. You have an example of a claim in one of our own patents. And if you read the text, you can see that it's quite boring. And it is boring because you need to define all relevant terms, because repetitions are preferred in the case of patents, and because we need to include all relevant explanations. And when you are writing the explanations, be broad in your detail, which looks a bit strange, right? But this is because patents only protect a product according to its primary use. And you need to prepare the following steps when doing this, thinking about traverse. So this examination that Frédéric talked about. If your explanations are incomplete or faulty, probably you will not have the possibility to amend them later. So you should think wisely in the first place on what you are doing. And maybe a good advice at this point is contact a patent attorney's office and hire a specialist to guide you through the process. You don't want to go through all of this alone, especially if you are patenting for the first time. After learning the language, you can start writing. And typically, as Frédéric mentioned, you can organize your material within 4 sections: an abstract, the description of the invention, where you should define the field of the invention, write the details of the invention, such as how you devised it, its main function, and the process for recreating it. Be sure to include how the invention is an actual improvement to any already existing products, and you should cite prior art in this case. The description should also establish that your invention is unique, useful, and non-obvious, and you might include some examples here. Then there's the most important part of the patent document, the claims. Patent claims define what we can say as the conceptual boundaries of your patent. They describe exactly which aspects of the invention are protected and which are not. And they should distinguish between independent essential claims and dependent accessory claims. And then, as mentioned before, you can include figures, drawings, schemes, photographs. Photos will provide visual evidence that your invention is real, and it makes you look more credible at the end of the day. And once the writing is concluded, you can file your application. So depending on the countries you have it identified before, you can file the patent in your own country or internationally. For example, at the WIPO, the World Intellectual Property Organization, or at some specific patent offices like the EPO, the European Patent Office, the United States Patent and Trademark Office, the USPTO, and other patent offices. In our particular case, we have further filed our patents at the Japan Patent Office, the JPO. And after filing, you need to wait for the report of an examiner to start what we can call the traverse. So traversing in a patent proceeding means to register a formal disagreement with the examiner's findings or requirements. So the traverse in patents corresponds pretty much to the answer to the referees in scientific papers, but it is quite different from this answer to the referees, especially in terms of the interaction we establish it with the examiners. The inventors cannot, as Frédéric mentioned, cannot introduce new material at this point. So you cannot introduce new explanations, new drawings, new claims during the traverse. In principle, you can only restrict those that were there in the first places. And the whole process can be quite time-consuming and also quite expensive, even if in some countries the number of iterations is limited. So as expected in this process, you should first understand the findings of the examiner. Is the examiner saying that some restriction requirements are needed because of lack of unity? Because there are several inventions in the same patent, as mentioned before, we had this problem. Because there's some lack of clarity or lack of definitions, lack of novelty, because finally the invention was anticipated before by other authors or inventors. Lack of citations of prior art or some formal or mechanical deficiencies. And then once you have understand the findings of the examiner, of course, you can respond. You can cancel or withdraw a set of claims and just pursue the other claims. You can amend some of the claims, trying to improve clarity, trying to restrict the scope of the invention. Or you can try to keep everything as it was, arguing for reconsideration, explaining the innovative aspects and defending unity. In some cases, you want to maybe pursue some of the claims you have withdrawn by filing a different application, so a separate application, which is called a divisional application. And we did
Luís,
this.
sorry, you have 1 minute left.
Okay. Okay. So we had to do this in the case of our reactor. So in our case, the outcome after 5 years between 2016 and the present date was a patent portfolio with 5 main patents, including 2 divisionals, submitted to 4 patent offices, corresponding to 12 active processes, leading to 20 traverses so far, with 2 patents granted, 2 almost granted, and the rest of it pending, corresponding to a total cost to date of 60,000 euros. So this is my last slide. In our case, our future steps are the following. Once we have finally the first patent approved by the EPO, we need to decide in which European territories we want to protect the invention and then file applications therein. And simultaneously, we can start managing our intellectual property, namely making final business decisions. So to conclude, giving a sort of advice, always plan ahead, namely defining a realistic strategy to convert your unique idea into a patentable invention. So thank you for your attention, and feel free to go to the website of our project to know more about Pegasus. Thank you.
Thank you very much, Luis, and thank you, Bruno and Elena. Congratulations for your work there. And thank you, Luis, because I don't know the rest of the participants. For me, it's been one of the clearest presentations about patents that I've heard ever. I'm sure, and I would like to confirm to the people that are following us that this presentation is recorded, this session is recorded, so I'm gonna be for sure one of the ones that is gonna revisit this recording every time that I need to know a little bit more about patents. And we have only, thank you for putting in there the link. So you have there the link of the that Bruno was just talking about. We have time just for two little questions because we have to close at 4:40 p.m. So we have a question from Sofia Shanko. Does the correspondence between the company inventors and the EPO through the whole patent examination phase become public? Who wants to take this one?
I can take it. Actually, yes, it's public. It's in the register. So after 18 months, everything is public. So, and you can access through the EPO website, which is called the register, with all the communication, what the publication, what the EPO says, the answer, everything is public.
Thank you, Frédéric. We have another question from Marco Macia. If I want to license my patent, do I have to wait for it to be granted 3-5 years, or can I start licensing it before? Who wants to take it? Maybe Luis?
Well, we are not there yet, but but what I can say, maybe Frédéric can confirm, but that depends a lot on your partners. Actually, you can start building a business without reaching the end of the patenting process. So that depends a lot on your partners and what they are willing to accept. Of course, to have the patent granted is a much better asset for you to negotiate the licensing that being still in the middle of the process.
Thank you, Luis. We have a last one from Sofia. Is the application to several patent offices necessary to cover the worldwide patents? This is a good one.
Actually, no, you have not. As I mentioned, there is no international patent. There is an international procedure. So you can start with this WIPO, as Luis mentioned, the international procedure, which is taken over by one office. So the EPO can do the international procedure on behalf of a specific international procedure. And when you arrive at the 32 months to the end, then you have to choose. So you already have part of you're not to the patent, but you did part of it. You have already a research report, an international one, and then you can choose. You can go in the US, in regional office like the EPO, in Japan, but you have no worldwide patent. You have to choose. But this procedure international, the advantage is during 32 months, you have already some insight, whether it's patentable, and you have time, you get a protection because it's published, and you have time to discuss and see whether you arrive to find partners or your industrial process is going the right direction, or it will not give rise to a product. So you have time. So, but you have no world patent or international patent. So if you see on, for example, I already see on shoes, you go international patent pending or international patent. No, it doesn't exist.
I think it's very clear. Even Sophia is confirming it. Thank you, everyone. Very clear. Thank you for your questions, Sophia. And thank you very much for the speakers, Elena, Bruno, Luis, and Frédéric. I think it has been really clear session and highlighting the importance of the patents, especially for the EIC beneficiaries and for all the people working in innovation. I wish you all the best for the slides and for the presentation and for the session. It will be As I say, it has been recorded and it will be available for you in the webpage of the EIC Summit. I wish you a very nice afternoon and good luck with the patents. Let's create more patents in Europe and protect our innovation. Thank you very much for your attention. Take care. Keep safe.
Thank you.
Thank you.
Bye.
Bye.